There is a very specific kind of person who signs a prenuptial agreement not before the wedding, but months into the marriage, quietly, on a Tuesday, without telling anyone at the dinner table. And when you ask that person why, they will not say, "I am planning to get divorced." They will say something vague about being prudent or protecting the family. But everyone who has ever been married or has ever watched two people slowly stop looking at each other across a table knows exactly what the document actually is. It is not caution, it is a forecast. It is someone who has already run the numbers on how this ends and is quietly getting their paperwork in order before anyone else notices the math. I bring this up not because I have opinions about postnuptial planning, but because on Monday evening, hours after Todd Blanche was sworn in as Attorney General of the United States, the Department of Justice's Office of Legal Counsel quietly posted a 21-page memo online. No press conference, no statement, no fanfare. Just a document uploaded late in the evening, the way you'd slide a prenup across a table when you were hoping nobody would ask too many questions about the timing. And the timing, as it turns out, is the entire story. So let's get into it, because good evening, welcome back, I'm glad you're here. And I promise you this is going to be worth the 20 minutes. Here's what the memo actually says, stripped of the legal varnish. For as long as executive privilege has existed as a legal doctrine, and it has existed in some form since George Washington first told Congress he wasn't handing over certain documents, it is applied to one specific relationship, the president talking to people who work for the president, cabinet secretaries, national security advisors, people on the government payroll inside the executive branch, giving the president information that later gets protected from subpoenas because the theory is simple. You want a president to get blunt, unfiltered advice. And people don't give blunt advice if they think it's going to end up printed in a congressional report. That's the deal. That's always been the deal. Government employee talking to the president about government business. 3 boxes, and you had to check all 3. What the new OLC memo does is take that very narrow, very specific doctrine and quietly widen it until it barely resembles the original shape. The memo, signed by Assistant Attorney General T. Elliott Geiser, argues that executive privilege can now extend to the president's conversations with private advisors, people entirely outside government, outside attorneys, business associates, family members, potentially. Basically anyone the president talks to, as long as 3 conditions are met. The conversation relates to presidential decision-making. It involves or reflects communication with the president or his direct advisors, and it stays confidential. Say those 3 conditions out loud slowly, and you'll notice something. They are not hard to satisfy. They are, in fact, almost impossible to disprove from the outside, which is sort of the point. Now, I want to pause here and just sit with how quiet this was, because it tells you almost as much as the memo itself. This wasn't announced at a podium. It wasn't tweeted. It was first reported by Punchbowl News, a Capitol Hill trade publication, which means the administration's own communications shop didn't lead with it. When you have genuinely good legal news for your side, you tend to hold a press conference. When you have a document that widens presidential secrecy to cover conversations with private citizens, you post it after 5 p.m. on a Monday and let a Hill newsletter find it. That's not an oversight, that's a filing strategy. So let's talk about why now, because why now is where this stops being a legal curiosity and starts being a story about what the people closest to Donald Trump actually believe is coming. Democrats are currently favored by most independent forecasters to retake control of the House of Representatives in November's midterms. And a Democratic House means committee chairs. Committee chairs mean subpoena power. Subpoena power means investigators who can compel testimony and documents from people who are not currently answering to anyone. For the first time in this presidency, there is a real, structural, non-hypothetical chance that Congress will be able to ask hard questions and legally require answers. That is the entire context this memo was written inside of. Not as abstract legal theory, as a defensive perimeter built roughly 90 days before the people who might need it start needing it. And it's worth being specific about who might need it, because this is not a hypothetical concern about future presidents in the abstract, although the memo does technically apply to all of them. This lands directly on top of an active legal fight. The American Bar Association has subpoenaed Boris Epshteyn, one of Trump's senior personal attorneys, over his role in negotiating deals between the administration and law firms. Epshteyn is not a government employee. Under the old doctrine, nothing about his conversations with Trump would have been protected as executive privilege, because he's not inside the government talking to the government. Under the new memo, suddenly there's an argument. Suddenly there's a shield, with his name roughly stitched onto it, delivered right as the ABA subpoena is playing out. I am not in the business of assuming intent I cannot prove, but I am also not going to pretend that's a coincidence worth ignoring. Now, here's where I have to be the annoying person who tells you the caveat, because the caveat actually matters, and most coverage of this buried it in paragraph 9. OLC opinions are not law. They're not court rulings. They're not binding on judges. What they are is the Justice Department's internal instruction manual, a document that tells federal agencies and administration officials how the DOJ believes the law should be interpreted, which then shapes how those officials behave, what they're willing to hand over, what fights they're willing to pick. A judge can look at this memo and say respectfully no, and has every legal right to do so. Jonathan Schaub, a University of Kentucky law professor and former OLC attorney himself, told reporters this week that the theory goes well beyond anything the office has formally endorsed before, and that whether it survives contact with an actual courtroom is genuinely uncertain. So this is not, contrary to how it's being described in some corners of the internet, an ironclad legal force field. It is closer to a very expensive, very confident opening bid in a negotiation that hasn't happened yet. But, and this is the part that I think gets lost, the fact that it's not binding almost doesn't matter for the next 6 to 12 months. Because here's what actually happens when Congress issues a subpoena and the target says no. Congress doesn't get the documents instantly. Congress has to go to court to enforce it. And that process, historically, takes years. Not weeks, years. There is a version of this where a private advisor gets subpoenaed sometime in early 2027, cites this memo, refuses to comply, and by the time a federal judge finally rules on whether the memo actually holds up, the underlying investigation is stale. The news cycle has moved 4 times over, and functionally, delay achieved everything that a real legal victory would have achieved anyway. You don't need to win the argument. You just need to make the argument take long enough that it stops mattering. That, historically, is the actual playbook, and it's not new. It's the same one that dragged out the White House counsel subpoena fights during the first term, where the fight itself was the strategy, not the outcome. I also want to give you the historical spine here, because without it this just sounds like generic partisan noise, and it isn't. The 2 cases that actually built modern executive privilege doctrine both came out of Watergate, United States versus Nixon, and Nixon versus Administrator of General Services, and both of them dealt exclusively with internal executive branch communications. Nixon lost, by the way, both times, which is a detail people conveniently forget when they invoke the Nixon era as some golden age of presidential secrecy. And in 2020, when Donald Trump himself tried to argue that financial records held by his accountants were shielded from congressional subpoena, the Supreme Court in Trump versus Mazars rejected that framing, warning that without the ability to compel information, Congress would be reduced to what the opinion called operating in the dark. That's not me editorializing. That's the actual language the court used 5 years ago, in a case involving this exact president. So when the current OLC memo argues that private outside government conversations deserve the same protection as internal government ones, it isn't extending precedent. It's asking for precedent that has been explicitly rejected before, dressed up as though it were always assumed. The reaction, predictably, split along entirely predictable lines. But a couple of responses are worth flagging because they weren't just noise. Senate Minority Leader Chuck Schumer put it about as bluntly as an elected official is willing to put anything publicly, saying the memo shows a president who is scared, who knows accountability is coming. You can agree or disagree with the framing, but the underlying observation is hard to argue with on the merits. You generally do not build an elaborate legal shield around conversations you're not worried about anyone ever seeing. And this isn't the administration's first attempt at narrowing what the public or Congress gets to see. Back in April, this same Office of Legal Counsel issued an opinion arguing that the Presidential Records Act, the post-Watergate law requiring the preservation of White House communications, was unconstitutional as applied. A federal judge disagreed and ordered the administration to keep complying with it anyway. So, this is now the second time this year that OLC has tried to redraw the boundaries of what gets preserved, recorded, or subpoenaed. And the second time, a court has been asked to decide whether the boundary actually moved or whether it just got argued about very confidently on paper. So, let's talk about consequences, because that's ultimately what this is about, more than the specific legal mechanics. If this theory survives, even partially, even in some narrowed form, a court eventually blesses. It doesn't just protect this administration. It becomes the new baseline for every future president, of either party, indefinitely. That's the uncomfortable symmetry nobody currently celebrating or condemning this memo seems eager to sit with. A Democratic president in 2029 inherits the exact same shield. Every future White House gets to argue that conversations with donors, family members, campaign consultants, and outside lawyers are shielded the moment those conversations touch anything resembling a decision. Congressional oversight, the actual constitutional mechanism by which the legislative branch checks the executive branch, becomes something you can simply route around, as long as your lawyers are willing to argue hard enough and your timeline is patient enough. That's not a Trump problem. That's a structural problem that happens to be arriving, this particular time, wearing a Trump-shaped hat. And then there's the more immediate, more human consequence, which is what this does to the actual investigations Democrats are preparing to run if they retake the House. Deals struck with law firms, business arrangements involving the president's family and associates, conversations with donors that shaped policy outcomes. Under the old rules, those conversations were fair game, because the people having them weren't government employees, and the old doctrine simply didn't reach that far. Under this memo's logic, all of it potentially becomes arguable, contestable, delayable, not proven to be protected, arguable, and arguable. When you have a Justice Department willing to litigate every inch of it and a court calendar that moves at the speed of federal court calendars, functions almost as well as protected does, at least for the 2 years that matter most politically. Here's the part I keep coming back to, though, and it's the part that I think actually explains the timing better than anything else. You don't build a legal shield this specific, this quietly, this fast, unless you've already made a private calculation about November that you are not saying out loud in public. Publicly, this White House is still projecting confidence about the midterms. Of course it is. That's what White Houses do, right up until the moment they can't anymore. But you do not spend the literal first 24 hours of a new Attorney General's tenure on an internal memo about shielding private conversations from a hypothetical Congress that, publicly, you claim you're not worried about facing. Actions like this are not what confidence looks like. They're what confidence looks like from the outside, worn by people who are doing math they haven't shared with anyone else in the room. So, where does this actually go? If Democrats fall short in November, this memo mostly sits on a shelf, a piece of institutional architecture nobody needed to test. If Democrats retake the House, this becomes the opening argument in what will likely be a 2-year legal war over what private advisor even means, fought out in district courts, appealed, reappealed, and quite possibly still unresolved by the time the next presidential election rolls around. Either way, something has already happened that can't be undone by a single court ruling. The theory now exists. It's been written down, signed, and filed. And legal theories, once they exist, have a way of getting used again by administrations of every party long after the specific controversy that produced them has been forgotten by everyone except the lawyers who keep the memo bookmarked for exactly this kind of Tuesday. I'll leave you with this. Somewhere in Washington this week, a White House press aide is presumably practicing the sentence, "There is nothing unusual about routine legal guidance." And they might even be right, technically, in the narrowest possible reading. It is, after all, just a memo, just 21 pages, just a document quietly filed the same evening a new Attorney General took his oath, addressing a Congress that, officially, this White House insists it isn't worried about. Nothing unusual about that at all. I'm Marcus Fenn, this is Borderlines, If you want to understand what's actually happening in this country instead of what's being announced about it, you know what to do. And I'll see you at the next border.